Hello, and welcome to the Arbitration Conversation. So in this arbitration conversation, we're going to talk to another leader in the field of arbitration, Professor Hiro Aragaki. He is a tenured professor of law at Loyola Law School in Los Angeles and a professional research associate at SOAS School of Law in London. His scholarship on arbitration is widely published in top US law journals. In addition to being a scholar, he also is dual qualified US and UK international arbitrator and mediator at JAMS. He served as a neutral for almost 20 years. He has substantial experience in arbitration. He is a fellow of the College of Commercial Arbitrators in the United States and a fellow of the Chartered Institute of Arbitrators in the UK. Needless to say, he is another rock star in arbitration. So thank you so much, Hiro, for coming and spending some time with us.
Thank you, Amy, for having me. I'm really honored to be here and excited to have our little chat.
Yeah, absolutely. So a lot of your scholarship, some of your distinctions when you talk about contract and procedure in arbitration. Maybe you want to explain what you mean by this distinction, contract and procedure in arbitration.
Yeah, sure. So, one of the things that always attracted me to ADR and arbitration in particular is that it really is at the crossroads, if you think about it, of contract and procedure. It's a procedure-like litigation, right? So all these procedural values come into play, but it's also born of a contract. You can't enter into arbitration typically unless there's some kind of voluntary agreement. And contract and civil procedure were always my favorite, subjects in law school. And, they both support each other, but are also in tension with each other. And these are the kinds of, doctrinal and theoretical issues that I think have animated a lot of my kind of arbitration scholarship. I mean, I've written on lots of different issues, but I think one of the themes has been to kind of explore that tension and that interplay between what I think of as contract-based values and procedure-based values. And, we talked about our conversation beforehand, and I know that we want to get to some practical issues about, arbitration. And I think that, I kind of inhabit this semi-unique space. I mean, a lot of scholars also do arbitrate. I know that you do so as well, Amy. But, we straddle kind of the theoretical and the practical. And one of the things that I think it would be interesting to talk about here is how some of these scholarly ideas, translate into practice, if at all, and how they do so. So I wanted to begin just with, an idea that I've developed in some writing, which is that, arbitration has come under fire in the past couple of decades for a variety of different reasons. And one of the critiques has been that arbitration is not as fair as courts, right? Arbitrators may be beholden to repeat players. There are no procedural rules in arbitration. Arbitrators don't have to follow the law, et cetera. So there is this concern that it's more lawless. It's not as fair or as just as an outcome that might be achieved in court, especially with appellate review and so on. And what I've noticed is that supporters of arbitration, they typically counter this argument by saying that, well, that may be true, but arbitration has all these other benefits, like it's potentially faster and cheaper. There's more scope for party autonomy and tailoring the process to a particular dispute. They rarely try to claim that achieving justice is equally important in arbitration as it is in litigation. So we've tended to focus on contract-based values, to generalize a little bit, like autonomy and efficiency, and less on more procedural fairness or justice values in this debate. And this is a little bit surprising to me, given part of my work in the history of arbitration, which is, as you know, the modern arbitration movement began in the early 20th century. And, at the time, one of the big issues that people were concerned about universally, not just within the arbitration circles, was that the courts were really unable to deliver substantive justice. And the main reason why was there were these arcane and complex procedural codes. So right now, the federal rules of civil procedure, only about 86 or so provisions. Back then, it was not uncommon for procedural codes to have more than 3,000 provisions. And so as a result, there were all these technical procedural rules that had to be complied with, and lawyers used them for strategic gain. And so as a result, the widespread complaint was that procedure is too complex. It allows lawyers to engage in sporting activity, and cases don't get decided really on their merits, on the substance. They get decided on procedural technicalities, which result in delays and appeals and retrials and so on. And ironically, back then, arbitration was looked at as a model for superior procedure and better opportunities for getting real justice. Why? Because as you know, procedural rules don't really apply in arbitration, right? Or there are very few of them. And so arbitrators had more discretion to cut right through all that procedural wrangling and get to a hearing on the merits and actually decide something on the law, right? And so I feel like we've lost a little bit of that justice-based conception of arbitration, primarily in the domestic arbitration debates. I think internationally it's slightly different. So, for example, the Supreme Court often says, the preeminent purpose of the FAA is to rigorously enforce arbitration agreements and to honor the free choices of the parties, right? Scholars, many of whom have been interviewed on your series, have claimed that autonomy is the primary value of arbitration. I'm not saying that autonomy is not important. I think it's certainly central. But I'd like to shift the conversation more and say, in addition to autonomy and efficiency, which are both important, I think we need to add justice, right? Justice in the sense of procedural fairness and substantive fairness. And also to think about what procedures are, are suitable for arbitration and how they can be reformed to, improve this goal. So for example, in the class arbitration cases like Concepcion, because of the contract filter that has dominated arbitration discourse and jurisprudence, the question of whether you can have class actions in arbitration becomes a question of mutual assent and unconscionability, right? Not about what would be fair, what would be just, how to put arbitration on a level playing field with litigation so that they can really compete and offer the same kinds of procedures, right? Now, obviously, we don't want to make arbitration into litigation, but my push in the scholarly realm has been to think about arbitration from a procedural as well as a contract perspective. One of your guests talked about the expression, arbitration is a creature of contract, right? And we all love that phrase because it's such a catchy phrase. But the problem with that phrase, from my point of view, and I've actually written about this, is that it kind of overlooks the other side of the equation, which is that arbitration is also a procedure. I like to think of it as a pillar of procedure, a model of procedure. What can the litigation process learn from how we do things in arbitration, for example? These are the kinds of things that are not really discussed in the scholarly and even practitioner literature as much.
But I'm with you. I agree. It's as you're talking, I'm thinking back to even the technical notes in 1925 behind the Federal Arbitration Act. And I can picture just what some of those notes really did talk about the procedural aspect and how you could create a better and more fair and cut to the chase and include trade norms in your procedure. So I think this is fantastic. I love this reframing.
Yeah, and so one of my articles was called The FAA as Procedural Reform. And what I tried to do was to say, look, the Supreme Court has their way of interpreting what the purpose and the original intent of the FAA was. And part of the reason why they were able to get away with that is that the legislative history is so scant and the text is so sparse. So you could almost concoct any story you want about the purpose, right? But if you actually situate the enactment of the FAA in the context of these broader judicial procedure reform movements, right, that led to the Federal Rules of Civil Procedure, for example, in 1938. So after the FAA was enacted while all these debates about simplification of judicial procedure were going on. And I think it has to be understood in that context, too. So, I'm happy to hear that you agree. It's always nice to hear that people agree with you rather than disagree with you. But I'd like to see that more. And if you even think about the FAIR Act, for example, and all the arbitration fairness acts from before, the debate has become reduced to, do consumers really agree to these arbitration clauses? Well, of course, they don't really agree, but it's more than just about consent. It's also about how good is the arbitration procedure for consumers? Could it be improved if we could have class arbitration as well? If we could put restrictions on class action waivers in arbitration and thereby allow a procedure of class arbitration to flourish and get tweaked and improved, and maybe, who knows, be better than what you can get under Rule 23, right?
Oh, yeah.
So
I've long argued for it's not simple, it doesn't have to be a zero sum, right? We can
yes.
actually come up with, and then I'm thinking through, because these are all really great points, really interesting and good stuff to sort of chew on mentally. But when you now kind of put on your hat as arbitrator and you're asked to serve as an arbitrator, maybe you want to speak to how these ideas and thoughts really inform the way you practice as an arbitrator.
Yeah. I mean, so one of the things that I've noticed, sitting in the arbitrator role is just how much, most of the conundrums that I am presented with, really they turn on these procedural fairness and, substantive justice issues. What's the right result here? And one of the things I've gained an appreciation of is just how difficult it is often to apply the law to the facts. The reality is, in many cases, it's not clear, who's right, and the burden of decision making. It's quite a huge responsibility, and that has been a humbling experience. But it's really all the more kind of focused me on these questions of justice. My own view is that my scholarship and my own take on the importance of procedure and justice in arbitration does influence, my approach as an arbitrator. So I'm not one of these arbitrators who will say, well, whatever the parties agree to, that's fine, right? Obviously, we have to be deferential to party autonomy. That's what people expect and so on. But this sometimes comes up, for example, with discovery, right? Where sometimes both parties, both counsel will say, well, we want to take 6 depositions in this case, right? Now, there's a difference in views among arbitrators as to what to do in this kind of situation, right? Someone who thinks that party autonomy is really important in arbitration might say, okay, that's fine. Do whatever you want. This is your process, right? And others might take a different approach, right? So my own approach here would be, it really depends on the case. So I've noticed, for example, that in employment cases, there seems to be just an understanding that there's going to be more discovery generally, right? So I tend to be a little bit more laissez-faire in that context. But in other contexts, if I feel that the extent of the discovery is disproportionate to the amount in dispute, for example, I will not be shy about kind of pressing the parties a little bit to think about, is this really what you want? Is this going to achieve what you think it's going to achieve? So, and it's a delicate thing to do, especially if both parties are on board that they want a lot of discovery, right? Usually it's the case that one party wants more than the other, right? And, there again, the approach that some arbitrators will take is to say, well, you're in arbitration. You're not supposed to have a lot of discovery, right? Discovery is not something that arbitration is meant for. That's not really my approach so much, because I don't know that that's a terribly convincing thing to say to lawyers. I think every case is different, right? So sometimes there are cases where there's a huge information asymmetry and one party really does need discovery, and you need to do that, again, for this procedure or justice-based conception to level the playing field. And so this idea that, well, arbitration is supposed to be fast and cheap, and so you shouldn't have much discovery, which again emphasizes the efficiency value that we talked about. That's certainly an important consideration, but it has to be balanced against the justice and procedure values. And so, these are the kinds of issues, that often arise. Another issue that sometimes comes up is when the parties brief certain issues and they've briefed them incompletely,
Mm.
or they've overlooked an issue, or they've overlooked some legal authorities. What do you do in that situation, right? So someone who might take a more kind of autonomy-based conception of arbitration might think, well, my role as the arbitrator is really to respect party autonomy and really just be their agent, right? And so this is what they briefed to me, and I've got to make a decision based on what they've given me, right? Others who might take a more procedural justice viewpoint might think of their role as an arbitrator more as a judge, right? Someone who can prod the parties more, ask questions that the parties did not ask of the witnesses, raise issues sua sponte, right? Maybe even do, research on their own. Right. This is a big issue internationally, actually. I don't know if you've been following some of those,
Yeah.
right? So there was a court in Frankfurt that recently did its own internet research. And the question was whether that was proper. And there are differing views even among arbitrators about this. Some arbitrators will say, no, not at all. You can't do your own research. And others will say, well, I always do my own research because, invariably the submissions by the parties leave things out, and so the short end of it is, I think, my practice has really also highlighted to me the importance of these procedural values and of thinking of arbitration, in this way. And I think that we owe arbitration this service, right? We as proponents of arbitration have to also start emphasizing these aspects.
Yeah. Yeah, no, when I first as a young lawyer, I was representing parties in arbitration. And, I always appreciated if an arbitrator was concerned about making sure it's a fundamentally fair hearing. And I remembered those words just always in my mind. It should be a fundamentally fair hearing. And always remaining true to that, I think has to be at the core for any practitioner.
Yeah. Yeah. No, I think it's right. And I think it's often overlooked. Yeah. Yeah.
Yeah. That's a great, wonderful. Well, this has been just a really great arbitration conversation. I have to say thank you so much for taking time in a busy summer. So thank you.
Yeah, you're welcome. Thank you so much for having me, Amy. It was a pleasure.